Counting down, and now it says go. So this is a lecture about judicial review and the principles that the court applies to judicial review cases. Judicial review is the jurisdiction of the High Court to review decisions of the lower courts and tribunals as made below it, and all actions of the executive, which is all of the public service effectively. So what can be reviewed? All decisions affecting legal rights and interests that are made by public bodies. So that includes decisions made by county councils on planning applications, decisions made by grants authorities on grant applications. If you get a SUSI grant, that can be reviewed. If they refuse you the grant, they can, or the level of grant that they award you, that can all be reviewed. A decision made by AIT that affected any of your legal rights is a decision of a public body that can be reviewed in the High Court. And the AIT have been reviewed in the High Court. I probably shouldn't say that on recording. Any decisions under derelict sites legislation can be reviewed. So that's a decision of the county council that affects your legal rights. If they declare your property a derelict site and ask you to do remediation works in relation to it. So the grounds for review are how the decision is made, but not why. So that's the important thing to grasp about judicial review. It's about the procedure followed in making a decision, but not about the decision itself, not about the rights and wrongs of the decision itself. So it's not sufficient to say, I wouldn't have made that decision. The court can't substitute its own decision for that of the decision maker. It looks at whether the decision maker took into account all the things it should have taken into account, whether the decision was fair, whether both parties had a right to be heard when the decision was made, whether the decision is based on proper considerations, and all of those things. So it's about the principles of natural and constitutional justice. And what is natural and constitutional justice? And this is a list of what's generally considered to be natural and constitutional justice. So there's a set of principles that should be applied in order to make a fair decision. And these fair decision-making principles apply to all public bodies that make decisions that affect your rights. They apply to the courts, they apply to tribunals. They also apply in scenarios like where your employer is making a decision about dismissing you or making you redundant. They must apply these principles of natural and constitutional justice. So the fair procedures and decision-making principles. And those principles are unhelpfully rather set out in Latin here. Audi alterum partem, or hear both sides. Nemo iudex in causa sua, no man shall be a judge in his own cause. That means he can't be biased or have a conflict of interest. Constitutional justice, that's the idea of fair procedures. Ultra vires, that means you're acting outside of your powers. So if the planning authority were to refuse planning permission for a decision for a property based on considerations that weren't to do with proper planning of the local area. So if they were, if you're talking about a factory that was that required an IED license, an emissions license, and the county council decided they didn't want a factory with releasing emissions into the local stream, and they refused planning permission for that reason, that would be ultra vires the powers of the council, because the council can't consider emissions. Only the EPA can consider emissions. So legitimate expectation. So a public authority has made promises to you that you would be granted planning permission for X, Y, and Z if you put your application together in a certain way, and you can hold them to those promises that are made at pre-planning stage. And then there's a duty to only consider relevant matters and not to take account of irrelevant matters or to make a decision for an improper purpose. So that will capture corrupt decisions as well, improper purpose. So they tried to sum it up in Haverty as the essence of natural justice is that it requires the application of broad principles of common sense and fair play to a given set of circumstances in which a person is acting judicially. What will be required will vary with the circumstances of the case.